All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please announce the case.
Thank you, Mr. President. Situation in the Republic of Kenya. In the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, ICC 01090111. And we're in open session, Your Honors.
Thank you. Appearances, please.
Good morning, Mr. President, Your Honours. For the prosecution, myself, Lara Renton, Anton Steinberg, Yasmina Suljanovic, our case manager, Regina Weiss, and Peter Schottman.
Good morning, Mr. President. On behalf of victims, myself, Orstin Arendstik, and James Mavia. Thank you.
For Mr. Sang, Jonas, myself, Katwak Egan, Caroline Buisman, Joel Bosek, Logan Hambrick, and Hona Lanham.
Good morning. On behalf of Mr. Ruto, Mr. Khan, Ms. Jamaraj, Ms. Sullivan sitting at the back, and Miss Laurie behind.
Nice, sir.
Yes. Ran out of the other.
Thank you. We will go, I believe, straight to the question or protective measures for the witness, I take it.
Yes, Your Honour. The prosecution has no further submissions other than its written filing, which was 1129, and of course we rely on the VW report. Thank you.
Defence Counsel. Mr. Keegan Katwa, Mr. Hooper, who goes first?
Your Honor, with your permission, I propose that Dr. Buisman does conduct the arguments on that issue.
Thank you. Should we be in... we can do this in open session, can't we?
On our part, we have no objection to doing it in the open session, Your Honor.
Mr. Hooper?
No objection.
All right, let's then get the arguments.
Good morning, Mr. President, Your Honours. Well, we take the usual position and we object to the request for protective measures. I'm looking at the prosecution submission, and this is 1129 at page... This is paragraph 44 and 45. This relates to this witness. Unfortunately, we cannot read the submissions because paragraph 44, which relates to a series of events relating to the security, is all redacted, so we cannot really comment on this. But we wanted to highlight the standard. Last time, on the 20th of February, Your Honours, you highlighted particularly the one aspect of Article 68 relating to the psychological well-being of the witness being of a great concern. However, we did not take it that you were overriding the standard that you had confirmed on an earlier decision, and I'm referring to the 3rd of September 2013 decision 902, where you also look at Article 68, and you look at 1 and 2, and you look at Article 64, 2, 6, and E, and you come to the following conclusion. This is paragraph 11. You say that these articles give you the power to order protective measures, protect the safety, physical and psychological well-being, dignity and privacy of victims and witnesses. But you also say that these measures shall not be prejudicial to or inconsistent with the rights of the accused to a fair and impartial trial. And this is paragraph 11. And then you go on in paragraph 13, that on the basis of these considerations, protective measures should be granted only on an exceptional basis, following case-by-case assessment of whether they are necessary in light of an objectively justifiable risk and are proportionate to the rights of the accused. And in paragraph 14, you say that it is a case-by-case evaluation which requires an individualized consideration of risk in each particular case. And then you also say that generalized assertions regarding the degree of domestic support for trials can be sufficient for these purposes, but you say that security situation in a particular territory may be pertinent when we consider the circumstances of a particular witness. So it still remains, even after what you said on the 20th of February, this remains the standard, and the psychological well-being of a witness is one aspect of this, is our submission, and this is how we understand you to have meant that. If we then look at the VW report, we note that it is a rather generalized report. It's not very different from the one relating to 409. We see only that there is no specific recent threats, and the only thing that this VW report is based on is the perception of this witness, which goes to this one aspect of the assessment, namely the psychological well-being, but it doesn't yet reach the level of an objectively justifiable risk in our submission. And then finally, we see that the VW again did not make its own investigation. It relied on what the witness said, and the witness does say that people, I hope I can say this in public.
You may not say compromising things in public.
Maybe for 1 second we could go into private then.
Private session then.
We're in public session, Your Honours.
Thank you.
Well, Your Honour well knows the position that's assumed by this defence team and has been consistently, and so we're supportive of the application of the submissions rather than just being made by Ms. Busman. At the same time, we understand the difficult position that you, the judges, are placed in when you receive the kind of application that the prosecution has made, and supported as it is by the VWU. We're also, of course, in this case, aware of the material that was provided us on Friday, the less redacted versions that were provided us Friday and yesterday, relating to various matters that have concerned this witness and the next witness. And the defence is again faced with the difficulty of presenting an effective argument, if I can put it like that, in the light of, or when confronted with these relatively ill-defined and unspecified concerns. We started investigating this witness effectively on Wednesday or maybe Thursday of last week. That may give the court at least a little indication of the investigatory process that we operate, necessarily witness by witness, particularly given the manner in which witnesses are shuffled and presented to us. And yet in that short period of time, we've conducted investigations that the prosecution could and should have done, which, again, and of course these are matters that will be presented to the court in due course, but again lead us as a defence to consider this witness part of a continuing scheme of deceit in this case. The problem, therefore, is this, that we, as the court, I know has seen repeatedly and observed, take a very different attitude towards the witnesses than that's taken by the prosecution. We're concerned that the VW do not, in fact, investigate these complaints more fully than they do. That's been voiced before. And our concern is that the principal reason why these witnesses are, in fact, seeking the cloak of anonymity is because they do not want to be seen and recognized by neighbors and by friends, by colleagues, and by wider society as the authors of the deceits that they present to the court. That's our view. If you like, that's our prejudice. But it's not ill-founded. And we've seen a litany of deceit in our submission already presented by the prosecution to this court, witness after witness. And it does raise, obviously, a considerable concern. But I go back to our recognition that it places you, the judges, in a difficult situation at this stage of the evidence, rather than after the evidence, perhaps. But we do support Ms. Busman's submissions this morning, and as you know, they are a reflection, and we repeat, of the view that we've taken and submitted since the outset of this case. Thank you.
Thank you, Mr. Hooper. Prosecution, any reply?
Just a very minor point, Your Honours. The prosecution recognises that each assessment must be individualised. However, we also think that they must be considered in the broader context of the situation as it prevails in Kenya. And as we have seen, while suspicion may not equal threat, there's certainly a risk that it may escalate that way. Thank you.
Thank you very much. Mr. Naratete, you were rising.
Thank you, Mr. President, Your Honours. We, the victims, we would support the prosecution's application. And in our view, those protective measures requested by the prosecution are justified and proportionate, at the same time necessary, Your Honour. And we fully agree with the recommendation provided by the VWU. Just a minor point to add, Your Honour, before I finish. In our view, Your Honours, objectively justify risk. What does it mean, Your Honour? In our respective submission, Your Honour should grant these protective measures not only where there has been explicit, specific threat against witnesses, Your Honour, but also where there is a possibility for witnesses being exposed to such threats, Your Honour. As provided in the recommendation of the VWU, we see that there is a possibility that this witness may face objectively justified risk and explicit threats in the future. Therefore, Your Honour, in our conclusion, we support the prosecution's request, and we believe that those usual menu of measures should be granted. Thank you.
Thank you very much. Thank you very much. We will render a ruling now on the application. The ruling concerns the application of the prosecutor made on the 23rd of December 2013, requesting the usual menu of in-court protective measures for witness 442. On the 3rd of March 2014, the VWU provided its assessment as regards the need of this witness for protection measures in the courtroom. The long and short of it is that the VWU does recommend that those measures of protection be granted to the witness, and the usual menu of protection being, of course, image and voice distortion, the use of pseudonym during the testimony, limited sessions in private in-camera sessions in order to prevent the identification of the witness, and the redaction of public records where necessary, again for purposes of protecting the identity of the witness. The Chamber is mindful of the submissions made by the defense and by victims' counsel, and we take those submissions into account. The Chamber is also mindful of its previous rulings as regards protection of witnesses during testimony. The Chamber is also mindful of events that have since occurred in the course of this trial following the initial ruling of the Chamber on the in-court protective measures. In particular, the efforts made by some people to unmask and intimidate witnesses who are testifying in the courtroom. In light of all the elements bearing on the circumstances, the Chamber does grant the request of the prosecutor. That is the ruling.
We interpret this as meaning that the VWU have had no particular contact or responsibility or management of this witness, and in particular has not been in the position of providing funds of any kind of description, either themselves or through any agency, to this witness in that period of time, at least until very recently, when of course we had the VWU directly concerned, we assume, in the management of passport and the costs and the arrangements for transfer of the witness to The Hague in order to give evidence. So our understanding is that it's been the prosecution throughout who have funded her, who have provided all the material support necessary for her in the past 21 months. And I mentioned that to the court today and submit it would be helpful and appropriate for the prosecution to clarify that. As I say, we only got this yesterday. Is that the position? Or have the VWU also had a material input over and above the transfer practicalities into this witness? We've had a sum expended by the prosecution of €3,500, which is certainly higher than the bread and butter sums that we've been getting from the prosecution in respect of most of the other witnesses. So it's with that sum in mind, and this email received yesterday, it seems to us that the VWU have indeed been excluded from any responsibility for support. But we would very much welcome confirmation of that from the prosecution this morning before the witness gives evidence, if they have that information to hand, of course.
Now, I would take it Mr. Sang joins in Mr. Kigen Katwa, counsel for Sang,
Yes, we do, Mr.
joined. So
Yes.
Your Honours, I can confirm the defence understanding is slightly incorrect, but rather than saying any more in public session, the prosecution is very happy to confirm the situation as it stands now and as it has recently changed to the defence in an email.
you will respond in an email. That's what you're saying.
Yes, we can clarify the situation for the defence by email.
All right. Well, we can always go into private session, and indeed, my application is, the Honour's leave to go into private session to raise the next matter, which relates to the material that we discussed Friday, or Thursday, I should say. You may remember there were, I think, then 4 statements from this witness, 442, 3 statements, and 1 witness from the next witness to come, 469, all in redacted form. We made an application that we served with a less redacted form. Now, because of the background of those statements, I thought it more appropriate to deal or discuss those, make my submission in respect of those in private session.
Private session, then.